Oyez, oyez, the United States Supreme Court is now in session. We are here on docket ending 2013-2014, Chester Comerford versus the United States of America. Are petitioners ready to proceed?
Yes, Your Honor.
Are respondents ready to proceed?
Yes, Your Honor.
Without further ado, Mr. Menkes, the lectern is yours.
Mr. Chief Justice, and may it please the Court. My name is Ruan Menkes, and along with my co-counsel, Ryan McDonald, we represent the United States of America. At this time, we'd like to reserve 3 minutes of rebuttal time.
It is reserved. Thank you.
Thank you, Your Honor. And would this Court like a brief recitation of the facts?
That's all right.
Thank you, Your Honor. I'll be addressing all matters relating to the Fourth Amendment issue, where we will be asking this Court to rule that the warrantless monitoring of a cellular phone violates the Fourth Amendment's protection of persons and their effects. We'll be asking the Court to rule in this manner for two distinct reasons. The first is that the cell phone is an effect within the meaning of the Fourth Amendment, and therefore falls subject to the common law trespassory test. And the second is that Mr. Comerford and U.S. citizens retain a reasonable expectation of privacy from Dragnet-style law enforcement measures. There are two applicable tests in the case at bar. The first is the common law trespassory test coming from the case of United States versus Jones. And the second is the reasonable expectation of privacy test as espoused in Katz versus United States.
Let's talk about the trespass test. You mentioned that the cell phone is an effect, and I have no issue with that. My issue is whether there is a physical trespassory invasion of that effect. Here, the government never took possession of the cell phone. They merely reviewed the data. So how is that a trespassory invasion?
Certainly, Your Honor. The government electronically intruded onto the phone when they, on page 4 of the record, in the first full paragraph in the second to last sentence, forced the phone to give up its ISMI number through rendering the encryption codes inoperable. What that means, Your Honor, is that this was an electronic intrusion. Now, the Court, in the case of United States versus Jones and in the case of Florida versus Jardines, never subjugated the invasion of an electronic invasion to physical trespass precedent.
In fact, Jones, we specifically limited our holding to physical trespass. Is that correct?
Yes, Your Honor, in that case, because the Court never needed to consider whether an electronic trespass had occurred. They mentioned that in the future, we might have to, and we contend that this is that case where we have to consider whether an electronic intrusion falls under the common law trespassory test, and we contend that it does. But the second...
Why is that a more persuasive argument than proceeding under the Katz expectation of privacy test? Why are you electing to proceed with digital privacy? I assume that that's your preferred argument over expectation of privacy.
Well, Your Honor, we argue that both are equally powerful, but the reason we bring this up is because in the 21st century, technology has evolved to such an extent that new bright lines are necessary in order to protect our U.S. citizens' rights, and that the Katz test is no longer sufficient by itself. But what is key in this case is that if the government fails either one of these tests, then a rule in favor of increased privacy rights is what should happen.
Without conceding either argument, and I understand that, do you believe petitioners' chances are better under the trespass theory versus the reasonable expectation of privacy theory?
Your Honor, I can honestly not say that the petitioner's chances are better under either one. Both, I believe, are incredibly strong, and both warrant the type of rule that we're asked for, that the government get a warrant when they are going to track or electronically intrude onto a cell phone, Your Honor. We choose to lead with the common law trespassory argument, Your Honor, as we believe that warrants the Court's foremost attention because we are asking for a semi-new rule in a gray area, Your Honor. But now we can turn to the second argument, and that is that Mr. Comerford and U.S. citizens retain a reasonable expectation of privacy from Dragnet-style law enforcement measures. In footnote 6, in the case of United States versus Jones, the Court noted that different constitutional principles may apply to Dragnet-style law enforcement measures. What the Court was referring to in this case, Your Honor, was the government's capability to go in depth into a person's life.
Just for edification purposes, did that footnote command a majority of the Court, or was that a concurrence?
Your Honor, this was in the majority opinion, Your Honor. What the Court was referring to here was the instance where the government was, in a period of 4 weeks, able to collect 2,000 pages of information from the GPS that was attached to Mr. Jones's car. In this case, and what the Dragnet is referring to here, is the government's capability to go in depth into a person's life.
But counsel, they didn't go in depth at all, did they?
Well, Your Honor, what they were able to do is collect constitutional and unconstitutional information, including information from the home, and then to subsequently filter through this information and throw away any unconstitutional information. That is the bright line definition of a dragnet-style search. And the intimate information that we contend they achieved is two-pronged. The first is within the home. As the court noted in the case of United States versus Cairo, whenever the government knows, through electronic surveillance, that there is a person or an effect that they are interested in is inside the home, then that is an intimate detail that the government is very interested in knowing about. But the second place where we run into an issue with dragnet-style surveillance is in what Justice Sotomayor referred to in her concurring opinion in the case of Jones versus United States. And what Justice Sotomayor said is that through using this type of tracking, in that case it was the GPS on the car, in this case, granted, it's the cell phone, but what this kind of tracking does is it allows the government to know intimate details, where you work, who your doctor is, if you need to go to an HIV clinic, whether you have a mistress, when you pick your children up from school, and the list goes on. The problem we have here is that the government, with the push of a button, can choose any cell phone that someone is carrying and then lock onto the cell phone and gain this information for any period of time.
Does petitioner concede, though, that the data received while Mr. Comerford was on public thoroughfares is fair game and is not an invasion of privacy?
Under the reasonable expectation of privacy test, Your Honor, not the common law trespassory test, if the government had watched Mr. Comerford go into his home and had then turned off the chum system, then this might have been a different case, as that addresses the first prong. The second prong is still what Justice Sotomayor talked about. But that could have been a different case. Equally, if the government had gone to Mr. Comerford's cell phone service provider and gotten this information, again, this could have been a different case. But that's not what they did.
Why should we hold that Mr. Comerford had a subjective expectation of privacy? He is a law professor who misunderstood the workings of the IMSI and did not turn his phone off.
Your Honor, all that catch requires, in Justice White's concurring opinion, is that the subject at least think that he is private. Now, according to page 3 and 4 of the record, Mr. Comerford knew of the ISMI system, he disabled the GPS and performed those necessary functions, and in doing so thought that he had disabled the ISMI signal itself.
Doesn't that reward the potentially ignorant defendant?
That may be true, Your Honor. But what we're coming back to is not whether he was a completely ignorant and stupid defendant, which we might concede he very well was. But in this case, the situation that we have is that the government trespassed onto his effect, whether he had a subjective expectation of privacy or not, and that the government engaged in dragnet-style law enforcement measures, whether he had a subjective expectation of privacy or not.
So it doesn't sound like under your analysis it matters whether they conducted this dragnet-style surveillance for 1 day or 23 days.
Your Honor, I recognize my time's about to expire. May I answer the Associate Justice's question? Thank you, Your Honor. Your Honor, while time may be a factor in dragnet-style surveillance, it is not the defining factor. So if it had been less time, that errs more on the side of the respondent. But the definitive thing is that they were able to separate constitutional and unconstitutional information that they obtained. And it's for these reasons that we ask the court to overturn. Thank you.
Thank you, Mr. Minkies. Mr. McDonald.
Mr. Chief Justice, and may it please the court. My name is Ryan McDonald, and I rise to continue argumentation on behalf of the petitioner, Chester Comerford, in the case of Barr. Specifically, I rise to address the Article 2 issue, where we would like to request that this court hold that the President exceeded his authority when he moved to indefinitely detain Chester Comerford in the case of Barr. Time permitting, we'll discuss 3 primary reasons for such a holding. Number 1, that the President acted outside of the parameters of congressional delegation of authority. Number 2, that an administrative review tribunal was an insufficient substitute for Comerford's right to a civilian trial. And finally, that the President lacked Article 2 wartime authority to detain the petitioner.
How did the President lack congressional authority when Congress said that if the President declares somebody an unprivileged enemy combatant, then he can be subject to a military tribunal? How is he exceeding his authority?
Your Honor, I believe you're referring to the Military Commissions Act, which would grant the authority to the President, if he's an enemy belligerent, to detain him indefinitely. But a further stipulation on line 3 of page 3 of the record states that even under the Military Commissions Act, he is still privy to a trial. Albeit even a military trial in that instance, Comerford, my client in the case of Barr, has not been granted a trial. He's been granted a military tribunal, of course, and my client contests none of the information regarding to the procedural due process arguments. Pro Bono versus Bush and Hamdi versus Rumsfeld, he was given the right to exculpatory evidence. My client waived the right to counsel, and he was also given a neutral arbiter in the military tribunal. All of that said, the legislative delegation of authority yet requires that a trial be granted to Chester Comerford in the case of Barr. And Ex parte Milligan would denote very specifically that if the civilian courts are in operation, as they were in loyal states in the time of the Civil War, then we ought to defer to the civilian court's ruling over a military court.
But we held in Kirin that an individual, even whom is a U.S. citizen, may still not be granted a trial based on his actions.
Of course, Your Honor, and there is a very small sliver of the law of war which permits an individual to be detained indefinitely without a trial, only if he is distinctly connected to an enemy force. And in Ex parte Kirin, the U.S. citizen in question by the name of Haupt was an admitted member of the German army who had received specific saboteur training from Berlin. And coming to the United States, having shed his uniform, was rendered an unlawful enemy combatant due to the fact that he attempted to hide his allegiance to the German army by basically donning civilian clothes.
Here we have an agreement to try to purchase a dirty bomb from people who are suspected of being Al-Qaeda saboteurs. Why is that not analogous to Kirin?
Two responses, Your Honor. Number one, the attempts to purchase a dirty bomb, the grand jury could not indict him on any counts related to the possession of those plans. And secondly, the ties of Denolf and Costello, the international arms dealers, were very tenuous and only suspected by the FBI, even after two very specific investigations. Furthermore, there are more even disconnects between the facts of Ex parte Kirin versus the case of Barr, and we'll address those now. Comerford is not like Haupt because of the following. Haupt, again, shed his uniform coming to the United States, was a member of a defined enemy force. Now, the National Defense Authorization Act in the case of Barr, which the President cited, 1021, when he detained Comerford, says that a covered person is an individual who is subject to detention, such as in Ex parte Kirin, an individual who is a member of the German ranks would be susceptible to detention as well. But Comerford is not a covered person for the following. He's not engaged in the 9/11 attacks, nor has he harbored any individuals who were participatory in those attacks. He's not materially or substantially supported combat operations against U.S. or coalition forces on behalf of the Taliban, Al-Qaeda, or other established international terrorist organizations. And he's not committed a belligerent act in support of those hostilities. Now, the NDAA is very specific in saying support of, quote, such hostilities, meaning that any action that Comerford would have taken, even if it was a threat, would have had to have been linked to an actual attempt to fight U.S. coalition forces, which Hamdi, in Hamdi versus Rumsfeld, correlated to the troop levels in Afghanistan, meaning that we're relating to a foreign active theater of war.
Even if we grant you that the statutory definition is not met, could the President, under the Youngstown Article 2 test, still detain Mr. Comerford?
Your Honor, petition will contend that that is not the case, simply due to the fact that it is not a significant enough threat to render his intervention. Furthermore, that Comerford is not an enemy combatant, but is simply acting of his own volition. And these are two separate arguments that play into the issue.
So are you suggesting that even if we're in Zone 1 of the Youngstown test, congressional approval, the action is still improper?
Absolutely, Your Honor. Even if there are certain arguments of congressional, and this court holds that he was within the definition of a covered person, he still did not receive a trial. And even if that does not satisfy this court, the Article 2 issue is not sufficient due to the fact that whenever this court has sustained the President in his action of detention, it has always been under very different circumstances. Hamdi versus Hamdi v. Rumsfeld was a situation in which the President was affirmed in that action, but Yasir Hamdi was found in the possession of a rifle while allegedly fighting in ranks with the Taliban. That is a distinction from Comerford, who bears no direct ties to an international or defined force at which the United States is at war with.
How does your argument not then just penalize the U.S. government for being more proactive and figuring out Comerford's ties before they become a danger?
Certainly, Your Honor. And the prize cases, of course, do give great deference to the President and be able to determine the nature of war and the state of hostilities against the United States. Even so, We are in a situation in the case of Barr and in the current classified war on terror where we are not with a defined enemy. Unlike ex parte Kieran, there are no uniforms to shed. And as such, there is a burden on the government to be able to present more factual evidence, petitioner contends, rather than simply having greater discretion under a defined enemy force.
That argument seems unfair for the government. It's harder to figure out who's fighting, so they have to do more work in a war that's harder to recognize?
Well, Your Honor, my client's right to have a trial and to be heard is something that cannot be arbitrarily overruled. And Ex parte Milligan puts forth that there is a very clear distinction from an executive authority and what it feared would devolve into, in its words, a kingly power. As such, we cannot permit the president in this case to use an arbitrary kingly power and, as Youngstown states, write him a blank check on authority. Rights apply in times of peace and in times of war.
So, counsel, what do we have to wait for? Do we have to wait till he possesses the bomb? Do we have to wait till he uses the... I mean, why can't we stop him now? Do we have to wait until he kills somebody?
We certainly do not have to wait until he kills somebody, Your Honor. However, if possession was in fact acquired, that would certainly be a greater argument for the respondents in the case of Barr. As in the case of Ex parte Kieran, a United States citizen helped was in possession of incendiary devices, just like Hamdi was in possession of a rifle while he was fighting with enemy forces. The fact of the matter is that my client today must be treated as a civilian criminal, not a wartime criminal. And yes, there could be action taken against him, absolutely. We've already attended on the Fourth Amendment issue that he may not be the smartest individual in pursuing such dirty bomb acquisition. However, that does not make him a wartime criminal, nor does it legitimize the president in interceding in such an affair.
Counsel, where does habeas corpus fit into all of this?
Certainly, Beaumanian versus Bush puts forth that the habeas corpus can be satisfied through certain alternative methods, like the neutral arbiter, like the ability to present evidence that would prove one's innocence, exculpatory evidence in this case, and all of that is provided for. My client does not necessarily challenge the procedural aspects of due process that are afforded to him. The substantive nature of his accusation is against the president's ability to detain him, specifically to detain him indefinitely. Because even in Hamdi versus Rumsfeld, where this court affirmed the president in his active detention, it was only until the cessation of hostilities as measured by the troop levels in Afghanistan. In the case of Barr, the president, in detaining Comerford per Article 2 and 1021, has not cited a quantifiable mechanism with which we can determine when Comerford would be released. And therefore, it can be presumed that the president can hold him as long as he so desires.
Well, what would you say to the argument, though, that executive deference is due here because one may not be able to figure out when hostilities end?
Of course, Your Honor, we would have granted him deference, but even in such an arbitrary war as we face, Hamdi was in the similar situation, the war on terror, and we still provided a mechanism, and such mechanism is not presented. Comerford is not necessarily needing to be deprived of his right to a trial, and it should be afforded to him, and the president oversteps his bounds. Thank you.
Thank you, Mr. McDonald. Ms. Roussel?
Mr. Chief Justice, and may it please the court, my name is Claire Rossell, and I, along with my co-counsel Cameron Etchart, represent the respondent, the United States of America, in the case at Barr. I'll be addressing the Fourth Amendment issue, and my co-counsel will be addressing the issue pertaining to Article 2 of the Constitution. We ask this court to affirm the ruling of the 14th Circuit and hold that the government's search did not violate Mr. Comerford's Fourth Amendment right to privacy. Time permitting, we address this for 3 reasons. First, that contrary to petitioner's claim, there was no trespass upon Mr. Comerford's private property. Second,
Can you address the argument that they're making to extend Jones to digital trespass? What do you say to that?
yes, Your Honor, we certainly can address that issue. In the case at Barr, we have an issue where there is no trespass, and this court has so far ruled that there is only physical trespass. An electronic trespass would be something entirely different than what we see in the case at Barr. An electronic trespass would be perhaps when the government actually hacked into a phone or computer and installed a device that would therefore track Mr. Comerford or inserted a virus into his phone. However, in the case at Barr, we see that there's no insertion or intrusion into any constitutionally protected area. This court specifically held in Florida versus Jardines that a trespass is when there is a constitutionally protected area that is searched through an unlicensed physical intrusion. And there was no physical intrusion in this case, and there was nothing analogous to a physical intrusion in the case at bar.
Do you agree, at least, though, that a cell phone as an effect is a constitutionally protected area?
Your Honor, it's certainly an effect in a constitutionally protected area. However, this doesn't mean that the cell phone signals that emanated from Mr. Comerford's effect were constitutionally protected, and that the police could not search those signals. Furthermore, Your Honor, there are two other issues I'd like to bring before this court, which is that Mr. Comerford had no reasonable expectation of privacy.
Actually, let me stop you there. I mean, the heat waves in Cairo were emanating from the house, and they were determined when captured with the thermal imaging device to be a violation of one's right to privacy. So what's the difference here?
Well, Your Honor, in that case, it was a question of whether or not the person had a reasonable expectation of privacy. And we held that he had a reasonable expectation of privacy inside of his house because the temperature was an intimate detail of the house. However, in the case at bar, Mr. Comerford had no reasonable expectation of privacy over the details of him entering and leaving his home. Such information could have been obtained through visual surveillance. And further, the information along public thoroughfares had no reasonable expectation of privacy.
But who are we to decide what details are intimate? We're dealing with a home, a place where the highest level of Fourth Amendment protection is given. Aren't all details intimate?
Your Honor, all details in the home are perhaps intimate, but in this case at bar, there were no intimate details of the home that were revealed. It's important to note that the CHUM could not precisely locate Mr. Comerford. In fact, it could only locate his location within about a 50-meter radius. This is roughly half the size of a football field.
But don't the facts indicate that they tracked him to a particular residence?
Your Honor, the facts of the record indicate that they knew when he was coming and going from home, which is the same information they could have obtained through visual surveillance. Page 5 of the record specifically states that they did not track Mr. Comerford's movements inside of the home. Therefore, there was no intimate detail that was revealed. In United States versus Cairo, this court held that the information that the police obtained from within the home was unconstitutional because they were verifying something that could not have been seen through visual surveillance, particularly the location of the canister inside of Mr. Cairo's home. And they held that this would have been the same as a police officer having to trespass upon Mr. Cairo's property and look in the window in order to see where the canister was.
Returning to the trespass argument briefly, I'd like to refer you to Sotomayor's concurrence in Jones and the fact that the length of time data was taken from Mr. Comerford is relevant here, 23 days. Is there a point at which this physical surveillance becomes a search based on the length of time that passes?
Your Honor, the length of time is not really an issue in the case at bar because the police never actually intruded into any constitutionally protected area. They merely observed Mr. Comerford in his travels along public thoroughfares, which he had no reasonable expectation of privacy over.
So if it was 23 years, then we still have no question about it, it's still permissible.
Your Honor, it's possible that this court could address an issue where there was a 23-year search in the constitutionality of that. However, a 23-day search, as Mr. Comerford merely traveled along public thoroughfares between a home and his warehouse, certainly had no...
Mr. Comerford might not have a reasonable expectation of privacy on the public thoroughfares, but he tried to disable the GPS, and to the best of his knowledge, he disabled tracking of his device. Isn't that sufficient? Isn't that equivalent to closing the door on the phone booth?
Your Honor, Katz versus the United States was a two-pronged test. It first required a subjective expectation of privacy and then an expectation of privacy that society was willing to recognize as reasonable. Mr. Comerford certainly had a subjective expectation of privacy, and we completely agree with the petitioner that he thought that he was not being tracked. The question before the court today is whether or not Mr. Comerford had an objective expectation of privacy.
People don't expect that they're going to be watched 24 hours a day for 23 days of the year. One doesn't have the expectation that all their physical movements when in public are going to be recorded and at some point in time, at the will of the government, sort of patched work together to present information about them. That's not an you're suggesting that we're supposed to ignore the technology has the ability to make it easier for the government, kind of leaving the government without any type of restraint.
United States versus Knott's particularly addressed that issue, Your Honor, and said that police efficiency is not automatically unconstitutional. In fact, this court has never ruled against police efficiency and using scientific or technological devices to enhance what they can observe through sensory faculties. And that's precisely what the government did in the case at bar. Particularly in this case, they were consistent with United States versus Knott's, which had originally held that any information that could have been obtained through visual surveillance is not subject to Fourth Amendment protection. And this
Counsel, isn't this exactly the Jones case, though? Isn't this exactly the non-intimate travel on the public highway information that we said in Jones you can't do?
Your Honor, this isn't the Jones case because there was no trespass upon Mr. Comerford's private property.
So, counsel, in Jones, we take a GPS device and we attach it to the car. That's a no-no. We can't do that. Unconstitutional. In this case, we co-opt a cell phone that's in somebody's pocket and turn it into a tracking device. And that's constitutional?
Your Honor, it's constitutional because the police merely were intercepting signals that were being broadcast into the public. Further, Your Honor, they never intruded into the phone in any way that is analogous to the United States versus Jones case, where they particularly invaded into an area through a physical trespass and planted a GPS device. Further, Your Honor...
Sotomayor seems to be suggesting in the concurrence in Jones that because so much information is disseminated, you know, into the public in the way that we interact in the digital world today, that to not find any expectation of privacy in this situation seems to suggest there's not going to be any kind of restraint on government's ability to invade people's effects and other things that they consider private. Where is the protection? Where is the restraint? This seems like a slippery slope here. Where do we draw the line?
Your Honor, we draw the line in whether or not the police invaded into a constitutionally protected area. And in the case of Bard, they did not do so. They merely tracked Mr. Comerford as he traveled along public thoroughfares and what could have been obtained through visual surveillance. They could have seen Mr. Comerford walk into his home. He had no expectation of privacy in his movements outside of the home, as this court held in United States versus Cairo. When they were transporting the canister into the home, there was no expectation of privacy over that information.
Can you briefly address why the chum is not in general public use?
Yes, Your Honor. The chum is, well, first of all, Your Honor, the Cairo versus the United States test, particularly, first of all, was underneath the CATS test and assumed that if a person first had a reasonable expectation of privacy, that we would then consider whether or not the technology was in general public use to see if that person had a diminished expectation of privacy. In the case at Barr, Mr. Comerford never had a reasonable expectation of privacy in the first place, so the question of general public use isn't even relevant.
Assuming that he did, how would you analyze it?
Your Honor, general public use means that that this is technology that could have been used by the public. And in the case of Barr, this is specifically what was the case. Mr. Comerford could have known through various Mr. Comerford could have known that this technology was available. And the technology available isn't just the chum, but cell phone towers in general. The very fact that a technology could connect to the cell phone and tell anybody Mr. Comerford's location is specifically what cell phone towers do, and therefore the chum was a device that was in general public use.
I want to pick on one word, though, use. Does the public use a cell phone tower?
Yes, Your Honor, if I may briefly.
Yes.
Yes, the cell phone towers are definitely in the general public use. People connect to the cell phone towers all the time and use cell phone towers to transmit information to their cell phone companies so that they know the location. Therefore, the chum acting as a cell phone tower was in general public use.
Thank you, Ms. Russell. Mr. Etchart.
Mr. Chief Justice, and may it please the Court, my name is Cameron Etchart, and I rise to continue argumentation on behalf of the respondent, the United States of America. In Aptheker v. Secretary of State, cited by Justice Thomas in his dissenting opinion in Hamdi v. Rumsfeld, this Court noted that it is obvious and unarguable that there is no greater government interest than the security of the nation. It is to protect this interest that we urge the Court to affirm the 14th Circuit and hold that the President acted within his Article II authority when he ordered the petitioner be detained. We ask this for three reasons. First, this Court grants significant deference to the President to protect national security during public danger. Second, the President had both the constitutional and congressional authority to detain the petitioner. And third, petitioner was afforded a full and adequate effective substitute for traditional habeas corpus.
Counsel, I understand that the exigencies of war sometimes call for the president to act. What is the limit of Article 2? Surely there must be a limit. And if this isn't it, what is the limit?
Absolutely, Your Honor. There certainly is a limit on presidential authority to detain people in the goal of protecting the nation. Opposing counsel argued the idea that kingly power could exist if the president was able to simply detain anyone he wants in a nameless war. We would even posit that prior to the Hamdi versus Rumsfeld decision, this might have been possible, where the president could detain anyone he wanted without any sort of review. In the case at Barr, petitioner asked the government to do the impossible. They asked the government to prevent harm to the nation, to prevent terrorist attacks. But at the same time, even though they recognize that terrorism is a faceless war where we cannot simply see the enemy soldiers and recognize them by their uniforms, they asked this court to apply an even harder standard to the government to protect the nation against faceless individuals. This simply defies logic and defies this court's precedent in cases such as the Price cases, where this court noted that the president not only has the power, but the duty to protect the nation against attack. And Justice Douglas, in his concurring opinion to Katz versus the United States, summarized this well, where he noted that the president has the duty to vigorously investigate breaches of national security. Specifically, this court has long held in Department of the Navy versus Egan, which is cited in Hamdi, that courts have long expressed reluctance to intrude upon the authority of the executive in military and national security affairs.
Counsel, I'd like to turn to the Youngstown test. Why is this case not in Zone 3? This is a civilian defendant who committed a civilian crime of drug possession, not different from the private seizure of steel mills.
Respectfully, Your Honor, we would urge this court to note that the president is not only acting with implied congressional approval, but he is also acting within his Article 2 authority, which puts him in that highest zone of authority, where he is not acting contrary to Congress, but rather is acting both from congressional implicit authority and constitutional authority.
When you say the term Article 2 authority, are you saying that is what takes us into Zone 1, or is it the congressional approval that takes us into Zone 1?
The president, Your Honor, as noted in Youngstown, can rely upon either of those sources of authority. Even if Congress specifically tried to stop the president from doing this action, if he is within his Article 2 authority, Congress has no say. But even though that could be the case, we posit that he is acting within both authority spheres.
Just to be clear, though, in that instance, that would be Zone 3, correct? If Congress specifically disapproved, that would be Zone 3.
Yes, the president would be at his lowest ebb of power, but that does not suggest inherently that that power does not exist. The idea that this court has long espoused is that detentions are important incidents of war. And
So we have Mr. Comerford, the government has him detained in one way or another. He's a U.S. citizen. He committed this purported dangerous act on U.S. soil. What's wrong with a civilian trial instead of a military trial in this case, or military tribunal?
The issue is whether Mr. Comerford is being held in military detention pending the end of hostilities. At the end of hostilities, the government will certainly either try or release him consistent with this court's holding in both Hamdi and Boumediene. Mr. Comerford, however, if Your Honor is referring to the grand jury indictment noted on page 5 and 6, although Mr. Comerford was not indicted by the grand jury at that time, the president is considering issues of national security, while the civilian courts can only consider domestic authority as far as civilian weapons charges. There's a bigger issue at stake here. The issue is that detention is necessary at certain points to prevent terrorism. And as this court noted in Boumediene versus Bush, proper deference must be accorded to the political branches when imposing detention in order to prevent terrorism.
You used the term cessation of activities,
Yes.
or of hostilities. Mr. McDonald pointed out there has been no announced cessation of activities. So does this power extend in perpetuity?
No, Your Honor, it does not extend indefinitely. Mr. Comerford, although not directly linked to Al-Qaeda himself, is indirectly associated enough that it is prudent for the president and this court to defer to that decision by the president. Mr. Comerford, as noted on pages 5 and 6 of the record, engaged in transactions with 2 internationally convicted arms dealers whom this government has suspects have ties to Al-Qaeda. Now, we agree.
You use the term deference, though. This is not like Curtis Wright, where there was an international issue. Here, this is purely domestic. So whatever deference the president might be given, it's certainly less than that of Curtis Wright, which leans us towards Zone 3, does it not?
In Curtis Wright, Mr. Chief Justice, we were dealing with that of foreign relations regarding whether the president could suspend trade to certain nations under congressional authority. In the case at bar, what we're looking at is whether or not Mr. Comerford had a direct enough link, a plausible enough link to Al-Qaeda that it merits the government's actions to prevent terrorism. A petitioner would ask this court to tell the government that the government cannot detain an individual to prevent terrorism until he commits the terrorist act itself. Petitioner puts such an immense burden on the government that they tell the court that in order to detain Mr. Comerford would actually have to commit an act of belligerency. If Mr. Comerford detonated the dirty bomb, I think there would be full agreement that he could be detained. The fact that the President of the United States was able to detain him before he engaged in hostilities, which we would posit is the only viable option based on the fact that he was attempting to purchase a radiological bomb from international arms dealers on U.S. soil.
Would it matter if he was trying to buy a radiological bomb or 100 assault rifles? Would that be different?
It could depend on the situation, Your Honor. However, we would posit that the purchase of a radiological bomb this way has no legitimate purpose other than the idea to commit belligerency. It is possible that purchasing rifles could have a slight legitimate purpose. Perhaps he was a gun collector. But the mere purchase of a radiological bomb of this type infers belligerency. It makes him immediately a suspect person.
When you say that, so if you purchased the radioactive weapons from a Secretary of State of another state, that would be permissible. I thought the tie was that they were suspected of being Al-Qaeda associates.
Yes, Your Honor. That is the connection that explicitly goes to congressional authorization. Congress passed the AUMF and the NDAA to give the president authority to detain people who were Al-Qaeda agents and those who tried to aid that organization indirectly. The president acted within that congressional authority when he deemed Mr. Comerford to be substantially supporting, or at least attempt to substantially support Al-Qaeda. The fact that we intercepted Mr. Comerford before he actually had the opportunity to kill hundreds or maybe thousands of people is an attempt that the petitioner asked this court to reverse his detention based on.
You used the word attempt. So let's say hypothetically we don't have a written contract to purchase the materials, and rather it's just a post on a website that said, I'm interested in getting these materials. Would that be enough of an attempt to trigger this military tribunal and all the applicable statutes here?
Respectfully, Your Honor, that would be a question for the president to decide. This court has repeatedly noted, such as cases as Kennedy versus Mendoza-Martinez, which Justice Thomas cited in Hamdi, that even if the president told this court every explicit reason behind national security decisions that he made, this court still defers to the president when determining such detentions and executive decisions because they're political questions. This court should not...
The question, though, was whether or not it would rise to the level that's required to meet that threshold. So what's your answer to that in that hypothetical that was just posed to you?
The threshold to what specifically, Your Honor?
To satisfy the need for the detention, whether it met the level requisite of evidence that was needed.
Mr. Chief Justice, I see
You
my
may
time
answer.
has expired.
Yes, please go.
Thank you. What rises to the level of whether the president should or should not detain someone is whether the president's action is plausible. If the president acted in a plausible manner, then this court should grant deference to him. If he acted in a completely unreasonable manner, then perhaps this court could review. Because he attempted to purchase a radiological weapon, we think it is fully plausible for the president to detain him. For these reasons, we urge affirmation. Thank you.
Thank you, Mr. Ratchard. Mr. Mankis.
Mr. Chief Justice, and may it please the court, First, a brief factual clarification on the Fourth Amendment issue. There's been a lot of discussion about where the ISMI number comes from. The record reflects that this is not simply cast open to the public airwaves for anyone to retrieve. Rather, the phone and the ISMI are best understood as a vault. The phone is the vault and the ISMI number is contained therein. And in order for the CHUM system to get this ISMI number, it has to render the encryption of the phone inoperable. And it is in that manner that a digital trespass onto a constitutionally protected effect occurred. Furthermore, Your Honor, the next problem we have within the Fourth Amendment is that of the dragnet-style law enforcement measure. While the CHUM cannot show someone's movements inside the home, it can place him within the curtilage of the home or at least within the home at some point.
When you say dragnet style, do you mean the length of time or the place? Because if Comerford was viewed for even 60 days on public thoroughfares, there would be no issue under knots.
Your Honor, the answer is both. What we're looking at here is the length of time. That is a factor. Had this been a 4-hour surveillance, the field would have been slanted in favor of the respondents. But what is most important and the defining factor is that they could gain any information that he was at home, which the case of United States versus Cairo held is an intimate detail of the home. And they could discard that all within one search. That is the dragnet-style law enforcement measure. Just one other observation under Fourth Amendment, Your Honors. And that is that there is a difference between being available to the public and being used by the public. The CHUM system is most certainly available to the public through sites like eBay, but the only indication we have in the record of it being used is by the government and by criminals. I'd like to turn this court's attention now to the Article 2 issue. And the most important point here, Your Honor, is that Mr. Comerford needs a trial. A trial charges someone, it tries them, and then subsequently convicts them based on the evidence. A military tribunal does not. The president most certainly has broad and discretionary powers, especially when faced with a threat. But when we have someone who did not commit a belligerent act, not even the grand jury could indict him of actually having these papers, then he is not a covered person.
Counsel, can you, I asked Mr. Etchert this question too. Does Curtis Wright expand the president's discretion here?
Your Honor, only in a certain way. In Curtis Wright, the problem is not so much the fact that Mr. Curtis was involved in smuggling operations. The problem was here that the president did have that discretion in a wartime. In this case, the war is with the terrorism. We cannot apply analysis of cessation of hostilities, which is necessary for time of war law to take place. Your Honor, it is for these reasons that we need new bright lines to protect our Fourth Amendment rights, and that the president needs to be restricted. Thank you.
Thank you, Mr. Mankies. Please be seated. I will spare you individual comments, the lateness of the day. This competition gets more difficult every year. It seems like the advocates just keep getting better. It was a split decision, but this year's regional champion is the petitioners.